In this video, we'll talk you through how we worked with a recent client, a physician who has a telemedicine practice in a management services organization, also known as an MSO. I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We've served hundreds and hundreds of healthcare clients just like you and helped them navigate healthcare and FDA legal issues. Among our clients are many medical doctors, chiropractors, dentists, psychologists, and other licensed healthcare professionals. Our clients also include telemedicine and digital health startups and much more. One of our recent clients is a physician who asked us to review a telemedicine MSA. Now, sometimes people ask for things and it isn't always clear what they want or if they know what they want. So this actually introduces the first point I'd like to make today, which is that healthcare entrepreneurs usually underestimate the amount of confusion out there when it comes to legal agreements for the healthcare industry. I like to call this myths and facts. These days, with all the information out there, all the Googling, everything on the internet, the avalanche of news, forms, resources, even 50-state surveys and compilations, it's really easy to imagine that you could say, hey Google, hey Siri, hey Alexa, or hey whoever will be your next AI virtual assistant, and presto, you get that legal document and everything is all tied up. Oh my gosh, back when I was in my 20s, back when I was dating prodigiously and all my friends gave me the wrong advice, not to mention, my own judgment was awry as I was kind of led back then by things that weren't quite in my own best interest, or maybe even by my evolutionary biology, but not at all by common sense. So, back then, if only I could have said like, hey Google, or hey Alexa, or, hey some other website, please, just tell me the answer. I'm sure that if the internet generates the perfect answer for me, then everything will be fine, right? The right career, the right person, and everything's just going to go right the way it's supposed to. I think that this is what Sigmund Freud meant when he said wish fulfillment. But the reality is that we use the internet, but there is a human component. Even lawyers do searches online to find good precedents. And right now, it still takes professional expertise to craft that form and make it work for your business, just like it takes in-person meetings to figure out if you're with the right person. I'm so glad I tied that around, otherwise it would have been embarrassing. So, I suppose there might be such a thing as an MSA telemedicine contract somewhere, but in the case of this particular client, there were two different things and they just kind of did their own mashup. And what they needed was a medical services agreement, or MSA, and then they needed an employment agreement between the medical corporation, which the physician also owned, and that the other medical doctors work for within the professional corporation. So I hope I'm not getting too deep into the legal structure advice here, trying to make this a little bit entertaining, but I'm simply saying that, with so much stuff available online, it's just easy to muddle all this stuff and create a kind of word salad where healthcare startups and healthcare ventures think they're getting what they need, canned and for free, and what they're actually doing is setting themselves up, and I've seen this time and again, for much more legal expense and much more trouble later. If you remember, in the old days, you could avoid going to the dentist. Maybe they didn't even have dentists, but I remember seeing in a movie that you could pull out a tooth yourself when it was rotten. So it's super simple. You take a piece of rope, you tie it to one piece of your ailing tooth, you take the other piece and attach it to the doorknob, and then you get a hearty swig of brandy, and then you ask your best friend to slam the door shut, and presto, out comes the tooth. So I think I did see that in an old Western, and it worked well in the movies. These days, though, it doesn't pay to be a cowboy or cowgirl on the Wild West. And we don't need whiskey or brandy because we've got anesthesia. No one needs to bite the bullet because we have more sanitary and less dangerous ways to titrate wakefulness and consciousness. You don't have to suffer. So actually, anesthesia is part of what brought in the medical profession, the modernization of medicine. Really, today you want to engage the professionals. Okay, I'm pitching a little bit here, but I want to tell you some things specifically that we did spot with the boilerplate word salad document that the client handed to us, hoping to avoid some real dental surgery, some real professional advice, where he wanted the canned form to do all the work, and thank goodness he didn't. So first of all, the document is trying to do too many things and therefore was muddling exactly who was promising to do what and to whom. So we streamlined the document to clarify that the obligations ran from the Professional Medical Corporation to the Management Services Organization, or MSO, not the other way. and not necessarily to the physician owner or to the individual medical doctors. Second, the compensation, the way it was written was unclear, and it didn't even state who would get paid, when, for what services. That can be a real problem if you don't know how or when you're going to get paid or by whom. Third, the document referenced some other state law, but the agreement was supposed to be for services in California. It's an easy change, but one that could be overlooked if you try to save money by just dumping in some document you find off the internet. Fourth, the document had no language to accommodate the client's existing obligation under HIPAA as well as California law, or the Confidentiality of Medical Information Act, or CMIA. And fifth, the document tried to have the MSO hire medical assistants. Now, this was a big one. It's a common problem. The MSO tries to do things that can create regulatory jeopardy of corporate and unlicensed practice of medicine, as well as illegal fee splitting. Among other things, we know that the MSO cannot hire medical assistants because the MSO can't practice medicine. And although medical assistants are not licensed in California, they're still helping to provide medical care under the direction and/or supervision of the physician, of course. We can talk more about corporate practice of medicine issues in other videos, and the point is that there are all sorts of serious issues that are worthy of being asked and addressed. At first blush, we normally do these in a legal strategy session, and then after that legal strategy session, we dive more deeply as we move into the retainer phase. If you have questions about our legal strategy session, please go to our website, click on the legal strategy session link. You'll find a lot of clarity. You'll find that the muddle, the word salad, the wish fulfillment, it's going to get clarified in that strategy session. Thank you for watching. If you still have questions, again, click on the link below, cohenhealthcarelaw.com/connect. You can send us a message, book an appointment. We'd love to hear from you. Here's to the success of your healthcare venture. We look forward to speaking with you soon.